Good evening, everyone. On behalf of AOR Aspirants Academy, I welcome each one of you to our lecture series number 3. Before going into the discussion for today, at the outset, let me thank Supreme Court Bar Association and Supreme Court Advocate on Record Association providing the space to study and to discuss about Supreme Court practice and procedure. On behalf of our AOR Aspirants Academy, I thank wholeheartedly the associations. With this gratitude of note, let us recite the preamble, because the preamble is the noble objectives enshrined in the Constitution of India. Moreover, it is our fundamental duties to cherish the noble ideals laid down by our founding fathers. We have to follow them, we have to cherish, and we need to abide by the Constitution of India. So being a fundamental duty, let us recite the preamble and request every one of you to recite along with me. We, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and to secure all its citizens justice, social, economic, and political, liberty of thought, expression, beliefs, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. So with this note, with this prayer, let us proceed for discussion, that is a scope of Article 32. So what we need to discuss about scope of Article 32? Just to see what had happened on the earlier occasion, to what extent we have discussed about Article 32, let me just give a recap. Firstly, we read Article 32 with 4 clauses, and then we try to understand the significance of Article 32 from the constituent debates delivered by Dr. B.R. Ambedkar. According to him, he said the Article 32 is the very heart and soul of the Indian Constitution. Secondly, from the judgments delivered by the Honorable Supreme Court, we came to know from these judgments that the Honorable Supreme Court had declared Article 32 and 226 as a basic structure of the Constitution, and that cannot be whittled down by enactment of Parliament by law. So having understood the significance, and then we discussed about the scope of Article 32 by taking the reference of Ramesh Thapur versus State of Madras, how it was discussed by the Honorable Supreme Court. From there, now we need to proceed further. So if we read carefully Article 32 Clause 1, let me just read quickly for your reference. Article 32 Clause 1, the right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed. So here we asked ourselves two to three questions. The right to move the Supreme Court. What does it mean? Who can approach the Supreme Court? That was the first question. Secondly, what are the appropriate proceedings? By what proceedings that you can approach the Honorable Supreme Court for the enforcement of your fundamental right guaranteed under Part 3 of the Constitution. So, first to answer, right to move the Honorable Supreme Court, who can seek for the enforcement of fundamental right? First, we must ask ourselves, what are the fundamental rights guaranteed to whom? From there only we are seeking the enforcement, for which I would like to draw your attention to Article 14. If you look at Article 14, there is a reason behind saying right to move the Supreme Court by not mentioning whether the citizens or the person or the company who can approach. That is silent. So if you read Article 14, it is equality before law. To whom? The state shall not deny to any person. Here they are using the word any person. 15, Article 15, prohibition. The state shall not discriminate any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. So 14 uses the word any person, 15 uses the word citizen. If you look at 16, there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. 16 uses the term citizens. 17, very important, abolition of untouchability. They do not refer to any person or citizen. It starts like this. Untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offence in accordance with law. Now coming to 18, abolition of titles. No citizen of India shall accept any title from any foreign state. 18 clause 3 says no person who is not a citizen of India shall, while he holds any office of profit or trust under the state, accept without the consent of the president any title from any foreign state. So 19 says all citizens. So if we go from 14 till 32, it deals with children. For example, Article 21A. Article 21 talks about any person. Right to freedom of life and personal liberty guaranteed to any person. Likewise, if we move on to Article 23, traffic in human beings and beggar and other similar forms of forced labor are prohibited. Here they do not refer to any person, any children or any citizen. They say traffic in human beings and beggar and other similar forms of forced labor are prohibited, similar to untouchability. Coming to Article 26, it says freedom to manage religious affairs. To whom? Subject to public order, morality and health, every religious denominations or any section thereof shall have the right. So if we closely see all these fundamental rights, some of the rights guaranteed to citizens of this country, some of the fundamental rights are guaranteed to person, some of the right which abolishes untouchability. So therefore any person who is aggrieved can approach the Honorable Supreme Court under Article 32. So those persons can come. Therefore, cautiously, our forefathers, founding fathers have not used the term only citizen can approach the Supreme Court or every person can approach the Supreme Court, even children. So meaning thereby, whoever to whom the fundamental rights are guaranteed, they can approach the Honorable Supreme Court under Article 32. This is the first answer to our question. The second aspect is appropriate proceedings. Very, very important. What are the appropriate proceedings? Initially, I would like to refer to the case law. Initially, the Supreme Court found the answer with reference to Clause 2 of Article 32. There is a case law, Daryo versus State of Uttar Pradesh. In this case, Daryo, D-A-R-Y-A-O versus State of Uttar Pradesh, reported in AOR 1961, Supreme Court 1461. I repeat, AOR 1961, Supreme Court 1461. In this case, the Honorable Supreme Court had an occasion to discuss about what is appropriate proceedings. According to the Honorable Supreme Court, they have observed the appropriate proceedings means, by referring to Article 32 Clause 2, they say we can approach the Honorable Supreme Court through appropriate proceedings, that is writ of habeas corpus, mandamus and other writs. So that is the answer according to this judgment, Daryo versus State of Uttar Pradesh. Time changed. The view of the Honorable Supreme Court with reference to the appropriate proceedings are also changed. What was the change? What was the evolution? The evolution, we can give credit to one leading case law on this aspect, Bandhuwa Mukti Moksha. Bandhuwa Mukti Morcha versus Union of India. 1984, Volume 3 SEC, page 161. 1984, Volume 3 SEC, page 161. Dear friends, you must understand the facts of the case. Bandhuwa Mukti Morcha is an organization. They were working to release the bonded laborers. So the organization made a survey and found that in Faridabad district, there were stone quarries in which nearly 11 bonded laborers were working there. They were not given proper condition, not proper environment, inhuman treatment. So what did Bandhuwa Mukti Morcha, the organization, they did? They wrote a letter to the Honorable Supreme Court. The Honorable Supreme Court considered the letter as a writ petition and appointed a commission, advocate commission, to find out the veracity of the letter. Please visit the stone quarries, inspect the premises. Was there any bonded laborers? Please try to find out and submit the report. Commission, as per the directions of the Honorable Supreme Court, they visited the premises. They found there were bonded laborers were really suffering in a worse condition. So therefore, they made a report. Immediately, the Honorable Supreme Court released those bonded laborers. They were hailing from Madhya Pradesh, Rajasthan, Uttar Pradesh. So they were ordered to release immediately by the Honorable Supreme Court. Now the question is, sir, already 32 clause 2 says you have to approach the Honorable Supreme Court through habeas corpus or writ of mandamus. Even the Supreme Court rules prescribes it has to be a petition form. It has to be accompanied by affidavit with other materials. But however, it was given go by to all the rules as well as to Article 32 Clause 2. They asked a big question. The Honorable Supreme Court judges asked the question to themselves, can we do so? The answer is yes. We can do so for the simple reason, we are not concerned with the form. We are not concerned with by what mode they approach us. They approach us for the enforcement of fundamental rights. So the destination is fundamental rights enforcement. Therefore, being the custodian of the Constitution, being the protector of the fundamental rights, we do not see by what appropriate proceedings they come. We see only one thing, that is the enforcement of fundamental rights. We will do it. Therefore, they have diluted the conditions by saying earlier view, no, in Dario versus State of UP, you can approach through by way of writ, but the Honorable Supreme Court, with a broader heart, with a noble thought to enforce the fundamental rights, they had given a finding that even a letter addressed to the judges of the Honorable Supreme Court can be treated as a petition, writ petition. Even a telegram can be treated as a writ petition. We are not concerned with the what mode. Our focus is on the enforcement of fundamental rights. So this is how they have diluted. Even they have diluted the locus standi also. I will be dealing with in short time doctrine of locus standi. Before that, we must understand how the honorable judges had considered the fundamental right to approach the Honorable Supreme Court under 32 is a paramount and a very heart and very soul of it. I can give you one judgment in which the honorable judges had expressed their anguish, pain, and the paramount interest of the Constitution and paramount interest of the citizens of this country. Beautiful judgment written by a full bench. Charles Sobroj versus Central Jail. Charles Sobroj versus Central Jail, reported in AOR 1978, Supreme Court 1514. The page number is 1514. Comprising of 3 honorable judges, Justice V.R. Krishna Iyer, Honorable Justice Desai, Honorable Justice O. Chinnappa Reddy. Justice Krishna Iyer beautifully writes his judgment. He is the author of the judgment, where he says, who is there in the prison? He is talking about the prisoner's valuable right. He has already committed offense. Therefore, he was sentenced by the court, due to which he is being a convict and undergoing the sentence. Does it mean that he has sent a farewell to his own fundamental rights? The answer is no. Though he may be a prisoner, though he may be a convict, but you cannot treat him as an animal. You have to treat him in comparison with the human beings. They are all human beings. So treat them properly. And then, my Lord, Justice Krishna Iyer goes like this. If a prisoner's fundamental right is floated or legislative protection ignored, the court's writ, this is very important, dear friends, the court's writ will run breaking through stone walls and iron bars. Our writ will run breaking through stone walls and iron bars to right the wrong and restore the rule of law. So we will not let the prisoner's right to be affected. We will restore the rule of law and we will correct the wrong Our writs will run through the stone walls and break the iron bars to restore the rule of law. How beautifully has been explained by our Honorable Justice V.R. Krishna here. So from this what we understand, Article 32 is very, very important. That is the reason it falls within the ambit of Part 3. Approaching the highest court of the land is itself a fundamental right. So from this what we have seen, we have asked questions to ourselves. Who can approach the Honorable Supreme Court? We have explained. What are the appropriate proceedings? You can approach through by way of writs as well as by way of letter. The only object is from the angle of the Honorable Supreme Court, we will enforce the fundamental rights of the citizens. Reason is our country, majority of the people were poor at that point of time. A poor cannot approach the highest court. Underprivileged, ignorant, they cannot count. Therefore, a letter is sufficient. How Arjun had target towards eye of the bird, similarly, our Honorable Supreme Court had a target towards the enforcement of fundamental rights. Right? So, with this, we have successfully completed Article 32, Clause 1 of the Constitution of India. Moving on to Article 32, Clause 2. There, it goes like this. Clause 2 reads as, the Supreme Court shall have power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate for the enforcement of any of the rights conferred by this part. So the person who is approaching the Honorable Supreme Court can seek for directions or orders in the nature of the writs that was added, that was incorporated in Article 32, Clause 2. Now, before going into these 5 writs, we must understand its origin. The origin had come from England. The writs were the powers entrusted with the kings to supervise any officials who commits the mistake. So it is a superintendence over the observance of law by their officials. If they fail to adhere to the rule of law, then writ can be issued by the king. So likewise here, state is there, state authorities are there. When we have a grievance as a citizens of this country or any person, we approach the Honorable Supreme Court for the enforcement of right against the state. So the origin comes from King's prerogative writ. Now moving on to the first and foremost writ, dear friends, writ of habeas corpus. Repeatedly questions are being asked from writ of habeas corpus or writ of mandamus, or how the differences between writ of prohibition, certiorari. So any one question might come from Article 32. So if we have a complete understanding of Article 32, we will be in a position to write our answers according to the marks it carries. Coming to habeas corpus, what does it mean? It is a Latin term. It comes from a Latin term, to have the body, to produce the body. Let us have the body. What does it mean? This is only the enforcement, remedial measure, writ of habeas corpus. But where does it flow? Where was the fundamental right guaranteed to persons? It comes from Article 21 of the Constitution of India. It guarantees every person has got a fundamental right for life and personal liberty. right? So once he is illegally detained, if a person is illegally detained, then he can file a writ of habeas corpus to the Honorable Supreme Court under 32 or under Article 226 before the Honorable High Court of any state, asking that I am being illegally detained, please release me. But if a detainee is not in a position to approach the Honorable Court, who can approach? Therefore, locus standi is diluted. According to the Honorable Supreme Court and High Courts, they have said even relation, wife, husband, son, daughter, friends, they can approach the Honorable Supreme Court on behalf of the detainee. Because he cannot approach by showing that he was illegally detained. Without any justifiable reason, he was illegally detained. Please ask them to produce before this Honorable Court. Release them. So this can be a prayer in the habeas corpus petition. So in any writ petition, the general practice of the Honorable Supreme Court is only when a person whose fundamental rights are infringed, they can approach the Honorable Supreme Court and High Court. That is a general rule. Exception is writ of habeas corpus. Yet another exception is public interest litigation. Even by way of public interest litigation, a person who is deprived from approaching the court by way of may not be financially sound, indigent person, or ignorant, or not having access to the justice, by way of PIL, it can be done. So, when detention is considered to be illegal, when a person has no authority to detain him, such detention becomes illegal. Now, when a court convicts a person and he is undergoing an imprisonment, we cannot say it is an illegal detention, because it is enforcing the rule of law, enforcing the judgment. It is a legal detention. But when somebody who has no authority, if they detain a person without any justifiable reasons, then it becomes illegal detention. Therefore, the Honorable Supreme Court as well as the Honorable High Court has got the authority, because our forefathers entrusted this sacred book called Constitution of India to the Honorable Supreme Court. So, Honorable Supreme Court has the authority to protect the fundamental rights of every citizens and persons in this country. Therefore, they have the authority to ask any person, on what basis you are retaining this person, on what basis you are detaining this person, please come and explain. Always produce the person. So they have the authority because they are the protector of our fundamental rights. So once such person comes before the Honorable Supreme Court and explains, and court is convinced, then writ of habeas corpus might be dismissed. If they are not in a position to convince about their illegal detention, then it becomes illegal, then person will be released immediately, forthwith. So from this, what do we understand? We understand that Article 32 being a fundamental right, the Honorable Supreme Court being the protector of the fundamental right, they can go to any extent to question any authority, to considering the paramount interest, paramount fundamental right of citizens and persons of this country. So with this, dear friends, the time is still 5. So we will conclude the session for today, and we will let you know what would be the next timing and everything. Thank you so much for your support, and thank you so much for your constant support and encouraging by your presence. We value everyone's presence, and we thank at this juncture Supreme Court Bar Association as well as Advocate on Record Association by providing this space and making us to utilize their space and deliver a lecture here to benefit the members of the bar. So I thank once again, and we will let you know what would be the next topic and date and time. Thank you so much. I value everyone's presence. Thank you. Thank you.